Welcome back to Chapter 4 of Judicial Process. Let's spend some time now thinking about state courts. In this chapter, we'll review the history of state courts, the organization of state courts, types of state courts, court reorganization and reform, drug courts, and consequences of court organization. The organization of American courts reflects but does not mirror their English heritage. In the colonial era, simple courts that followed the form but not the substance of English courts were established, that adjudicated cases and performed administrative tasks while they were created as needed and reflected local customs. Early American courts, after the American Revolution, showed that power shifted from the courts to the legislatures. Former colonists were skeptical of judicial power, and critics complained when courts declared legislative acts unconstitutional under judicial review. Over time, courts began to emerge as an independent political institution. Courts in our modernizing society have increased in volume and types of litigation. Courts still reflected a rural society but had to change based on industrialization, so specialized courts were created, for example, small claims, juvenile, and family courts. In 1931, Chicago had 556 independent courts. The haphazard expansion of courts, like in Chicago, created a confusing array of courts and jurisdictions. State and local response was to create even more courts. So new specialized courts like small claims and juvenile and family courts grew even more. The growth was sporadic and haphazard, and it created political opportunities for judges and administrative staff, and resulted in complex and confusing state court systems. Trial courts of limited jurisdiction, or lower courts, were those jurisdictions where jurisdiction is limited to minor civil and criminal cases. They're also called inferior courts or lower courts. So 85% of all judicial bodies in the United States, or more than 13,000 courts with more than 18,000 judicial officers, are considered lower or inferior courts. Those courts decide a restricted range of cases and are controlled by local governments. They're not courts of records. There's no official verbatim transcript of the proceeding that is kept. And appeals go to courts of general jurisdiction, like district courts, and are termed trial de novo. Table 4.1 gives you a chart showing the number of case filings in state trial courts in the year 2010. Criminal cases are processed by millions of misdemeanor cases each year involving disturbing the peace, or shoplifting, or public drunkenness, or things of that nature. These kinds of criminal cases generally impose a maximum fine of $1,000 and no more than 1 year in jail. Many handle preliminary stages of federal cases, of felony cases, for example, arraignments and setting bail and things like that. These courts in civil cases usually decide cases under a set amount, often referred to as small claims courts. They use streamlined procedures to provide quick and inexpensive processing of claims. Small claims cases are less formal than other cases. Those are trial courts of limited jurisdiction. Let's think of trial courts of general jurisdiction. These courts are responsible for major criminal and civil cases, also called major trial courts. They decide matters not specifically delegated to lower courts and have considerable variation across states with jurisdiction geographically defined. And there's no shortage of business in these general jurisdiction courts. They handle 35 million cases compared to 1.5 million federal cases. Table 4.2 shows you major trial courts in the United States. These trial courts of general jurisdiction handle criminal cases where they decide primarily street crimes compared to federal courts. They hear felony cases, and the number of cases has continued to grow. Most criminal cases do not go to trial because defendants plead guilty or plead out. There's debate about what penalty to apply to a not guilty or innocent plea. These courts also handle civil cases. Civil cases outnumber criminal cases by 2 to 1. Most of those are tort cases or personal injury cases. Common cases include domestic relations, estate issues, personal injury, and contract disputes. Tort cases, often personal injury cases, are private or civil wrongs in which the defendant's actions cause the injury to the plaintiff or the property. Tort cases are 5% of all filings, but 66% of all trials. Just as the federal system, there are intermediate courts of appeals. And those are created to relieve caseload growth. These courts of appeals must hear all properly filed appeals and are the final say in most cases. Most trial court decisions are affirmed by the courts of appeals. Table 4.3 shows you state intermediate courts of appeals in the United States. In the state of Texas, we have courts of appeals. The courts of last resort. They're usually referred to as the state Supreme Court, but not always. These state Supreme Courts, or courts of last resort, have a varying number of judges. All have some original jurisdiction, but mostly discretionary jurisdiction where they choose the cases they will hear, like the Supreme Court of the United States. They have ultimate review for state law and constitutional issues at the state level. Similar processes as the United States Supreme Court, but with more cases. Table 4.4 shows you state courts of last resort in the United States. In the state of Texas, we have a split court of last resort for criminal versus civil matters. We have a Texas Supreme Court for civil matters and a Texas Court of Criminal Appeals for criminal matters. Research on state Supreme Courts is a relatively new focus of political scientists. It's important for policymakers to understand how state Supreme Courts function. This research focuses on why state Supreme Courts operate the way they do, and have found that judges have been shown to react to case facts, electoral conditions, and other political institutions within the state. Let's think for a moment about Justice of the Peace Courts, which is a lower court. Its origin is in small, isolated English towns, and its purpose was to create simple and speedy justice applied by the local community. Most justices of the peace are actually not lawyers at all, but are elected with short terms and low salaries in that jurisdiction. Critics argue that justices of the peace are outdated, and reforms focus on upgrading the personnel or abolishing the system altogether. What does it look like to upgrade the personnel for justices of the peace? Well, the job is low status within the legal system, and so justices of the peace may not have legal training. So reformers suggest including training programs or abolishing the Justice of the Peace Courts altogether. Abolishing the JP Court faces major obstacles because the influence of powerful non-lawyer judges who like their jobs is pretty high. JPs are accessible justice. Advocates believe common sense justice practiced in a local community is most desirable, and they're considered the people's courts. Let's think for a moment about municipal courts, which is another form of lower court. These are urban counterparts of the rural Justice of the Peace Courts. Big city case volumes required more than one court, and political machines viewed courts as a source of patronage. And so these kinds of courts have often been tainted by corruption or scandal. In the progressive era of the 1920s and 1930s, reformers tried to remove politics from municipal courts. Urban court caseloads require quick disposition and is considered the assembly line. The response was to create shortcuts to resolve cases quickly. Initial appearances are usually the final one. So these are things like traffic court, things of that nature. Few trials are held at all in these municipal courts, and attorneys are rare, and the focus is on the sentencing. Over the years, municipal courts have been so hard on its citizens that people have asked, is the process the punishment? A new look at municipal courts sees the process as less chaotic than it looks, and a court trying to respond to problems, not crimes. Another kind of lower court is a juvenile court. It's unique in that it blends civil and criminal matters, and it's a product of the progressive movement as well. The underlying philosophy of juvenile courts is the legal doctrine of parens patria, or the state as parent. All states have juvenile courts. Regular judges may rotate through them on assignment. Typically, those juveniles who are subject to the juvenile court range in age from 16 to 18 and may be tried as adults for some other crimes. Most cases are delinquencies, status offenses, and child victims. In juvenile courts, status offenses involve acts illegal only for juveniles, offenses like running away, truancy, or possession of alcohol. Sentences may be for juvenile detention for such acts. Child victim petitions involve neglect or dependency, and they are taken up in court, but not the fault of the juvenile. Court acts as a social services agency in these types of cases. There are generally two standards for deciding appropriate disposition in juvenile courts: the best interest of the child and the best interest of the community. Reformers believe that a multiplicity of courts is inefficient and inequitable, and so they call for a unified court system which reflects 5 general principles. First, reformers call for a simplified court structure. Secondly, they call for a centralized administration. Third, they call for a centralized rulemaking authority. Fourth, there's a call for centralized judicial budgeting. And lastly, they call for statewide financing of the judicial system. Most states have a unified court system, but not necessarily all 5 conditions exist. Support comes from legal elites to reform the system in line with those 5 conditions. Opposition comes from local governments who worry about loss of control. And so overall, court reformers have made considerable success. What are the next steps in court reform? Well, it's better to organize courts from the bottom up, involving those most affected. Courts must understand the realities of the courthouse, the law in action. Reform must avoid elite bias, tendency to try and label certain types of cases as garbage. Consider all parties involved in legal proceedings, and any new efforts need to focus on how to improve the quality of justice, often within alternative types of courts. Drug courts are a response to the war on drugs and efforts to arrest, prosecute, and imprison drug offenders. Treatment approach to drug offenders is premised on belief that treatment will reduce the likelihood of rearrest, and sentences are tied to drug treatment or dismissed if treatment is completed. The city of Miami reports drug court treatment programs have lowered incarceration rates, less frequent rearrests, and longer time to arrest. Other changes include efforts to advance therapeutic justice, focusing on therapy instead of punishment. We have to evaluate drug courts by asking about the continued growth, but also increased costs. Are there unintended consequences? One judge claims drug courts have increased the number of prisoners in jail on drug charges. How do we measure a success of a drug court, a specialized lower court like a drug court? What are the consequences of court organization? 50 state court systems with significant differences but also similarities means that there's so many court lawyers that there may be decisions made to shop for the most friendly court. Local control and local corruption of courts is still locally based, and they reflect the local communities they serve. Local control has advantages. It links courts to the people they serve. But there are disadvantages too: greater opportunity for corruption and graft, more opportunities for injustice. So in conclusion, state caseload growth has been tremendous over the years. Response to this growth has not always been well planned or evaluated. Common elements include basic 3-tier system with specialized courts. The state court system is a common target of judicial reform, and state courts do not exist in isolation and have proven to be highly adaptable.